Welcome, everybody. Thank you all so much for being here tonight. My name is Peyton Rose Michelle. I use she, her pronouns, and I'm Executive Director of Louisiana Trans Advocates. I'm so grateful for you all for joining us tonight. I see more and more people are joining us by the second. Um, I'm so grateful to join you all, even though we're here under not the best occasion. Tonight, I'm here with colleagues from Forum for Equality, Southern Organizers Academy, Trans Legal Defense and Education Fund, which will soon be Advocates for Trans Equality, Lambda Legal, and the Family Equality Council. We really wanted to include some national partners in this call to really uplift their work and thank them for being involved. And we wanted to give our statewide partners a chance to take a nap. Before we get started today, I just want to thank everyone who sent emails and calls and texts and anything else to legislators. It was a hard year, and I think we're all grateful that each and every one of you contribute and, hold us up as we fight. Despite all of our efforts, Louisiana legislators passed some really bad anti-trans bills. And that's what we're here to discuss today. Those bill numbers from the session were HB 608, which is the Gender Regulation and Bathroom Bill, HB 121, which is a name and pronoun regulation bill for schools, and HB 122, which is the Don't Say Queer bill for schools also. We'll be talking about how they impact communities and how folks can navigate those situations. And we'll also be talking about some of our wins from this session. Throughout the call, you're welcome to comment any questions. This is on multiple social media platforms. Feel free to comment on whichever one you're on. We will get it, and we will do our best to reply to the questions either in the moment or at the end during a Q&A section. And I think that's all I got for you right now. So before we get started, we're going to give it on over to Natalie from Southern Organizers Academy, and she's going to get us started with some healing vibes to make sure that we're all, feeling good in this space as we move into it. And I'm going to bring Natalie on stage now. Thank you so much for joining us, Natalie.
Of course. Thank you so much for having me, Peyton. And yeah, shout out to all the organizers who've been kicking butt at the legislation, no matter what the results are.
Thank you so much. Take it away. Do your magic. Love you very much.
Thank you, my love. Yes, welcome everybody to the Louisiana LGBTQ plus Know Your Rights session. We want to make sure that folks feel grounded, fortified, and are feeling good before we dive into some really what can be seen as heavy, but we know are actually just hurdles for us to continue to fall into the line of radical organizing that's been happening for decades and decades before us, right? And so before we do that, we really want to be in our bodies. And the point of offering something that's healing and that's supposed to be restorative before we do some of these things and as we close is that we're always returning back to ourselves, back to our ancestral DNA, back to our individual wisdom, and reminding ourselves that we are human before we're anything else, and that we deserve the right to be in homeostasis and to be whole. And so humor me a little bit. We're going to have a little bit of fun. Some of the first things about remaining whole, it starts with yourself, right? So knowing your body. And we're going to play a little humming game. It's said that the act of humming is a regulator. I was talking to one of my neighbors recently, and they were telling me how sound therapy, sonic waves, are going to be the future of healthcare medicine, right? So using certain frequencies or using certain vibrations to attack fibroids, to attack any cancer cells in the body, or to attack anything that might stop us from living full and whole lives. And so that and a few other things got me thinking, this has been a practice in organizing, particularly in trans and queer, Black and brown organizing for decades, y'all. And so what we've always done is we've always sang. We've always used the act of sonic waves and vibrational work to sing, to lift our spirits, to encourage us to continue to organize and to kind of lay out the strategies for what organizing does. And that can be seen in the Negro spiritual child. It can be seen in music today that is uplifting. and we're going to practice it. So the first thing I want to ask folks to do is to hum with me, right? I want you to give me a nice, from the top to the bottom. Let me hear your full range. I can't hear you, but I want you to hear your full range. Do give me one of the, taking a deep breath. Hum with me, just to hear where that lands in your body. And then I want you to stop when your chest is vibrating, right? So for me, if I hum, this vibrates right here. The higher things vibrate right here. And the more mid-level things, they vibrate around my chest area. So that vibrates right here in the chest resonator. And what I'm going to invite folks to do is to hum and anything that vibrates in your chest, knowing that that's where our heart chakra is, knowing that, excuse my dirty room, that's where our heart chakra is, knowing that's where we kind of grow our practice of loving ourselves, expanding our own practice of love to each other, and to know that's where our vitality comes from, right? So wherever you are in your heart chakra, I want people to be able to breathe in and allow their bellies to extend, let that belly extend, and then hum at your heart chakra. The number 3 is a number for alignment and moving forward with alignment. And so we'll do that 3 times, fam. And remember, humming at our heart chakra activates it. It activates our vitality to continue to organize and do the work that we do. And it also helps to lower anxiety. It also helps to move through the lens of love. And so we'll do that 3 times. We'll take 3 breaths. We'll hum at our heart chakra. And then we'll close and move on and get to learn about some of these bills, honey. And I encourage folks as they hum to tap, right? To release any of that. And you can tap here. You can tap anywhere in your body. Some of the best points that I found to tap are my forehead, on the temple area, at the tenseness of the jawline, and around my chest. Grief lies in our breath and in our lungs. Stress and anxiety can be up here. It also shows up in our faces. And so let's just get into our bodies. And as we hum, I'm going to encourage folks to tap where they would like to. So let's take a breath. You can close your eyes. You can find a point on the wall. Anything that feels really good. Let's take a second to breathe in so big that our belly extends. And when we exhale, let's hum on our heart chakra tone while we find a place to tap on our bodies. So that one more time, fam. Breathe in so big that your belly extends. And let's exhale with the hum on our heart chakra tone. And to make sure that we're moving in alignment with our divine numbers, let's do that one last time. Finding some place that can use some extra love on your body tonight and tap on it. Remind it that it exists. Remind it that it is worthy. No matter what we might hear tonight, we can always return to the love that we've been honing. We can always return to our bodies and reminding ourselves that we have value in being here. And so let's breathe in so big that your belly extends. Find a place on your body that could use a little bit of extra love today. And let's exhale on our heart chakra tone. Finally, before we move into day, we want to leave this space knowing that anything that's come around us or come out of us, you want to just swipe it off. It no longer has a place in our bodies. If you have inches, throw your inches back. And let's move into tonight, into this call, knowing that no matter what wins or losses we had this legislative season, that we always have the capacity to move in from a space of love that our bodies are here and deserve to be here and will be here. And with that, y'all, thank y'all for allowing us to ground. And I'm going to welcome in Elena, and they're going to talk a little bit about HB 608. Hey!
Hi, thank you so much for that incredibly grounding and beautiful reminder of our worthiness as we enter some difficult conversations. We can do this and do this from a place of groundedness and empower. Thank you so much.
Thank you very much. And thank you, love. Thank you so much. All right, see y'all at the end of the call, fam.
See you at the end. Thank you so much for the introduction. And as Natalie said, my name is Elena or Alana Jokum. I use she, aya pronouns. I am an attorney and I am the policy director at Transgender Legal Defense and Education. May have advocates for trans equality. We are merging with National Center for Transgender Equality, but that happens a little bit later this summer. So right now I'm still at TILDEF. I'm based in Ohio. I was the executive director of Equality Ohio for nearly a decade. And so I am so with you in the trenches in terms of state advocacy. Be so proud of the fight that you have put up as a state against these terrible bills. We are now going to tonight try to navigate as best we can what the bills mean when they become effective on August 1st. So I'm going to talk tonight about HB 608. This is the so-called Women's Safety and Protection Act. A couple of reminders before I dive in. I am not providing legal advice tonight. If you or anyone you love has a specific situation, you really should consult with an attorney that is barred to practice in Louisiana. I am giving high-level policy analysis of this bill and some general recommendations, but not legal advice. So let's dive in. HB 68, the so-called Women's Safety and Protection Act, this is one of several similarly styled bills that we have seen across the country that passed this session. Essentially, they are trying to define sex in a very narrow way that would allow for discrimination against transgender people. And specifically, 608 focuses on trying to prevent transgender people from using restrooms or locker rooms that correspond with their gender identity in schools and in other public buildings. To be clear, and I want to emphasize this, to be clear, we believe that 608 and all the bills like this directly conflict with federal law and are illegal. These violate, among other things, we believe Title IX, which is discrimination in schools, PREA, the Prison Rape Elimination Act, and other federal law and constitutional principles. These bills will be the subject of litigation, but that is most likely to arise as they are applied in different situations. This is a bill that's difficult to challenge right out of the gate. It is one that we need to see how it is going to be applied first. So although this also focuses on government-controlled bathrooms, not private spaces, government-controlled correctional facilities, domestic violence shelters, and public and charter schools, it does try to apply these very narrow definitions of sex that focus on reproductive organs at birth across all of the Louisiana Code. So to be clear, we will be watching vigilantly for how this is applied in practice. So how this law applies, this is the basics of what 608 is going to try to do. It tries to apply rigid and discriminatory definitions of sex across all of Louisiana state law and agency rules focusing on reproductive organs at birth. It is trying specifically to say that sex does not include gender identity or expression under state law. It explicitly names that the definitions will apply to public and charter schools, multi-occupancy restrooms, changing rooms, dormitories, and overnight sleeping quarters during school trips. It would apply specifically to domestic violence shelters, whether run by the state or by an agency like contracting with a nonprofit, and with adult and juvenile correctional or carceral facilities. The law requires that those above entities designate multi-use restrooms, changing rooms, or sleeping quarters for the exclusive use of either males, females, or members of the same family under that rigid definition of sex. And it also requires that those entities take, quote, reasonable steps to provide individuals with privacy from members of the opposite sex. Although the law explicitly names the above facilities, it could apply to places that receive public funding depending on implementation. And again, that's something that we are all going to be watching for. To be clear, it does not affect private establishments unless they receive funding from the state. That isn't particularly common. What we also, however, want to be aware of is that sometimes private businesses get confused. Sometimes they want to make their policies in alignment. We could see an uptick in private entities that are not subject to this law actually trying to restrict access. The key exemptions in this bill are that it allows for single occupancy restrooms, changing rooms, and sleeping quarters that are not designated by sex to be used by anybody. It's not requiring that single stalled areas be designated by sex and policed in this same manner. It provides exemptions for anybody who is in a multi-use restroom facility needing medical or law enforcement aid, for aid in a natural disaster or declared emergencies, or for custodial and maintenance of those spaces. Additionally, nothing prohibits entities from adopting policies necessary to accommodate persons who are protected by the federal American with Disabilities Act, or to help young children in need of physical assistance. So there are ways to provide policies to support people who fall into those categories. It will be a curious area to see how those policies develop. The penalties for violating this. I want to be clear that this does not criminalize people for using restroom spaces. It's very important. We abhor the law, but it doesn't create a criminal penalty. It is a civil penalty, and it creates a cause of action against people who violate this by those who are suffering harm or likely to suffer harm. And it tries to say that there is a presumption of harm to anybody who experiences being in a multi-use facility, essentially with a transgender person, which of course we would push back on, but I'm simply reporting on how the law is drafted. Remedies include injunctions, protective orders, damages, attorney fees, and some other remedies. And the statute of limitations, meaning how long a person has to bring a cause of action, civil cause of action, is 2 years. So that is an overview of what the law does. What I want to also try to provide are some recommendations that are, again, not legal advice, but recommendation in this period. Reminding us again that it seems to conflict directly with federal law and is ripe to be challenged. But in the meantime, we want to encourage people to focus on restroom spaces where you feel most safe. This legally is trying to apply to government spaces, but again, we might see an uptick in private spaces trying to apply it either out of confusion or out of trying to match their policy to government policy. Single-use restroom spaces may be the safest right now because they are just an exemption to the law in total. Buddy systems are really helpful for restroom spaces, not just for your individual comfort and for your protection and safety, but also in the case of hostility, it would provide you with a witness who would be able to counter any action arising from that. Finally, if you experience discrimination or hostility in any restroom, changing facility, carceral facility, or frankly, anywhere, whether subject to HB 608 or not, please report this to Louisiana Trans Advocates and to Forum for Equality. Legal of the challenges to the law will really depend on how it is enforced and how it is used against trans folks. When we know about those instances of discrimination, it helps to formulate the legal challenges needed to fight back against the law. Thank you so much. I appreciate the opportunity to be in community and space with everybody here tonight. And I'm really hopeful that we can stand strong and stand together in the face of this difficult and discriminatory law until it can be challenged. Peyton, I'm going to kick this back to you.
Thanks, Elena. I really appreciate it. Now we're going to swiftly move on over to Nicholas Haidt from Lambda Legal, who's going to talk about the other anti-queer school bills that were passed this legislative session. Welcome, Nick. Thanks so much for being here.
Thank you so much for having me. And thanks also to Alana for trying to untangle that really complicated web of a law that has been passed. I will do my best to likewise untangle HB 121 and 122. But before I do that, just so folks know who I am, Nicholas Height. I am born and raised here in Louisiana. I've been practicing law for a little over 10 years now, first in my private practice and now at Lambda Legal. And I'm super excited to also be part of the legal team that's currently suing to fight Louisiana's ban on gender-affirming care. But like I said, what I'm going to talk about are HB 121 and 122. I'll start with HB 121. Folks think of this as sort of the dead name bill. I think it might be more useful to think of it as the affirming name and pronoun ban. I think it's useful to think of it as a ban because it's mostly written in the negative, listing out things that folks aren't allowed to do in school. So I'm going to go through and address each category of school community member first: students, school employees, and then parents. And in each of those categories, I'll talk about what things those community members aren't allowed to do according to this law, as well as some of the things that the law doesn't address and that they may be able to do. Like Alana, because I'm an attorney, I'm obligated to let folks know this is not legal advice. It's just an assessment of a law, of a policy, and shouldn't be considered legal advice. So first, HB 121, just like 608, uses a definition of sex that is really reductionist and says that a person's sex is determined solely by the reproductive organs that they have at the time of their birth. Doesn't take any consideration of a person's gender identity. So that's sort of the framework that we're talking about when we talk about pronouns in this context. The pronouns that the law is referring to are the ones that it says logically flow from a person's reproductive anatomy at the time of their birth. The law also talks about what a person's legal name is, and says that the legal name is the name that's put on a person's birth certificate at the time of birth. It's unclear if this cuts out the ability to recognize legally changed names. But if anybody thinks that they are impacted by that particular component of the law, feel free to get in touch with me. Likewise, the law has a pretty broad definition of what a school employee is. It includes, but is not limited to, teachers, bus drivers, extracurricular staff, contract employees. I think, it's safe to say basically anybody who gets paid by a school is going to be considered a school employee for the purposes of this law. So first, the community group, we'll talk about first students, right? What does HB 121 say that students cannot do? It says that students cannot be asked about their chosen name or pronouns as part of a school policy, and they cannot be disciplined if they refuse to give their chosen pronouns if they're asked. Students cannot be forced to refer to their classmates or other school employees by a chosen name or pronoun, and they cannot be disciplined if they refuse to do that. So what does this mean then? Students, it appears to me, can inquire about the chosen name and pronouns of classmates and school employees, right? Because that's not part of a school policy. But nobody is obligated to answer those questions, right? Students can voluntarily offer their chosen names and pronouns without being asked. There's nothing that says that they can't do that. There's nothing that says that they can't use the chosen name and pronouns of their classmates voluntarily. Again, it's not a school policy, and they're doing it by choice. No one's forcing them to do it. And likewise, students can respect the chosen name and pronouns of school employees voluntarily. Next, we'll look at school employees and what school employees are not allowed to do under this law. So employees, just like students, cannot be asked about names or pronouns under school policy. They cannot be disciplined if they refuse to give pronouns in particular. Employees cannot be forced or compelled to use any student's chosen name or gender appropriate pronouns, and they can't be disciplined for that refusal. Employees likewise can't be compelled to use coworkers' chosen name or pronouns and can't be disciplined for that refusal. So what this means is that employees, teachers, school staff can voluntarily share their name and pronouns. They can voluntarily use gender appropriate pronouns and the chosen name of their coworkers, and they can voluntarily use the chosen name and gender appropriate pronouns of students as well. It just means that if at any point a teacher doesn't want to do that, no one can force them to do it. A parent can't force them to do it. An administrative superior can't force them to do it. It all has to be voluntary if someone wants to do that. An important note while we're talking about school employees, teachers, administrators, if a parent opposes the use of an affirming name and pronoun for a student, and they find out that a teacher has been using an affirming name or pronoun, that parent can request the school to take corrective action against that teacher. The law doesn't define what the corrective action has to be or should be. It just says they have to take quote unquote corrective action, right? If the principal then intentionally refuses to take corrective action, that complaining parent can sue. If the principal does take the corrective action and the teacher then intentionally refuses to correct their action, the parent again can sue. And this right to sue also exists for students who are over the age of majority. So if you have a high school senior who's 18, technically they could sue on their own behalf if they wanted to. So students, school employees, the law really just says no one can be compelled within a school to use the gender affirming names or pronouns that people are requesting. They can do it voluntarily, but no one can be forced to do it. And so that leaves us with parents. So parents, the rights that parents have is sort of displayed in the inverse, right? So like I just mentioned, the parents have the right to sue to stop someone from using gender affirming names and pronouns, but parents can't force anybody at a school to use gender affirming pronouns or the chosen name for their child. Earlier versions of the bill had that sort of affirmative right on behalf of the parents to dictate or to determine how that school was going to treat their student. That's no longer part of the law. So if school administrators and teachers and school employees choose to voluntarily affirm a student, they can. There's nothing to say that they can't, but no one can force them to. The last thing I'll note is that this law does explicitly apply to both public and charter schools in Louisiana. And I make that note because the next law, HB 122, has a bit of a question mark around that component. So HB 122, Louisiana's Don't Say Queer, Don't Say Gay law, uses language that is very broad and is probably confusing. It's a little bit confusing even for me. I'll do my best to describe what the law does, but it's possible that my description is just going to leave you with more questions than answers. I apologize for that on the front end. The reality is that laws like this, and this one in particular, are most likely written in that way intentionally, because the more vague they are, the more schools and individuals are going to err on the side of caution to avoid any kind of negative consequences. And so they're going to self-censor more than the law might actually be allowed to proactively censor folks. So HB 122, the Don't Say Queer bill, what does this deal with? It's a speech ban. I just want to be clear about that. And it covers grades kindergarten through 12. It applies primarily to school-related adults and less so to students. Constitutional rights of for free speech extend further for students than they do for people who are at work. So folks who are at school for work have fewer rights than folks who are there to learn. I use the term school-related adults because the law applies to teachers, school employees, which is not necessarily defined, but is perhaps self-evident based on what we just read in 121, and also covers other presenters at a school, which again is undefined in the law and is, pretty ambiguous what exactly that means. All of those individuals, teachers, school employees, and other presenters, right, are banned from covering topics of sexual orientation or gender identity in class discussion or instruction unless it's part of a state-approved curriculum. There's no definition of what it means to cover a topic. Does that mean an in-depth analytical discussion, or does it mean a passing mention of sexual orientation or gender identity? Your guess is as good as mine. That is a perfect example of that sort of vague language that I believe is used intentionally to cause teachers and school administrators to dial back even further than they might actually have to what's going on in classrooms. The law does not say, and probably legally can't say, that the limits to discussion apply to student-initiated or led conversations, right? The language that it uses is talking about school employees, teachers, other presenters, them covering topics in discussion or instruction. So, does that mean that if a student brings up an issue or a student initiates a conversation, that there's an obligation to proactively stop that conversation? Unclear. I think, what is likely to happen is that student-led attempts to initiate discussion are going to be halted by schools just out of an abundance of caution to make sure that there's no argument that they're violating any of the terms of this law. Halting those conversations, however, may in turn be a violation of students' free speech rights within the school. So this is really going to put school in between a rock and a hard place in many ways. Teachers, school employees, other presenters are likewise banned from covering, again, topics of sexual orientation or gender identity during any extracurricular, sporting, or social activity that is under the jurisdiction of a school or school governing authority. This part of the law seems pretty clearly intended to target GSAs, gay straight alliances in schools, as the primary activity that happens under the jurisdiction of a school that also covers the topic of sexual orientation and gender identity. However, as someone who played team sports all through elementary, junior, and high school and into college, I can guarantee you that discussions and arguably a degree of instruction covering the topic of sexual orientation and gender identity happens on athletic fields and locker rooms all the time. It wasn't that long ago that there was quite a bit of press and national conversation about just exactly what locker room talk consisted of. So arguably that sort of discussion and conversation is going to run afoul of this law as well, even though I'm pretty confident that's not the kind of discussion that lawmakers intended this to cover. Additionally, there may be questions about how a school hosts a prom with male and female dress codes without having a discussion that covers the topic of gender. But again, I am confident that's not what lawmakers were thinking of when they copied and pasted this law together. Lastly, the law says that no teacher, school employee, or other presenter may discuss his own sexual orientation or gender identity. What it means to discuss one's sexual orientation or gender identity, again, very vague, very broad. Does it mean that a teacher can't correct intentional misgendering, right? If I'm a teacher and a student insists on calling me Miss Nick as a taunt, am I not allowed to say, please don't call me Miss, I'm a man, you have to call me Mr.? Is that a discussion of my gender identity that violates this law? I don't know. The last sort of caveat and sort of placeholder in this law is that nothing about the law prevents a student from seeking guidance from a teacher or a counselor outside of school hours with prior parental permission. So this seems to create an opening for affirming social groups and gatherings to exist that can include teachers or school staff, as long as they're not under the jurisdiction of the school, not school sanctioned, not school supported, happening outside of school hours, and students have prior permission from parents to participate. So again, like I said at the beginning, this may have just caused more questions than it answered, and I do apologize for that. That is the unfortunate way that this law is written. It's likely going to get applied very differently by every different school district and individual school. So I really encourage parents and students to increase your knowledge about your rights within the school setting, whether it's being protected from bullying and harassment, increasing your opportunities for participation in decision making through PTAs or school feedback sessions, and increasing the steps just generally in community to be supportive and caring outside of school, since these laws are making it clear that schools are no longer intended to be safe spaces for our students, for our kids. So that's HB 121 and 122. If folks have additional concerns or questions, please feel free to reach out to me. I will, or someone will hopefully drop my email in the chat, inheight@lambdalegal.org. But in the meanwhile, I'm going to hand it over to Sarah Jane, who's going to come on and talk about legislative updates, some wins, some good stuff, hopefully.
I'm going to try my best. And I appreciate you so much, Nick. This is really dense and information to cover in such a limited time also. So I think you just did a beautiful job in getting us ready for some really unfortunate laws going into effect very soon. So thank you so much. Hi, everybody. I'm Sarah Jane Guidry. I use she, her pronouns, and I'm the executive director of Forum for Equality. And I really I want to pause for a moment and make sure that our LGBTQ youth and students that are getting ready and preparing for a new school year understand that you deserve every right to succeed and thrive in your school and in your community, and to be your authentic self. And we support you, and we're here trying as hard as we can to create the community around these laws as best as we can. So please take this information, if you're a parent, if you're a student, and bring it back and bring it forward to other people in your community. This will be continued as a living video, so you can reference it at various points after this evening. And I am going to do a very quick legislative update on bills that technically would be, I guess, considered non-LGBTQ specific, but absolutely impact our community on a broader level. So I'm gonna try and sandwich this with some of the bills that did fail, that were bad bills that did not continue on. Some of them are repeats from previous years, and obviously are insights into what the next 3 years of this Landry administration might look like. So these are bills that failed in the 2024 legislative session that we were following and working on as a community and as a coalition. So one of the first ones that's very important was House Bill 975. That was authored by Representative Horton, a name that you probably will be hearing quite frequently throughout the evening, as a lot of these laws were authored by her. And this was to provide relative to a minor's consent for medical procedures and treatments. It was later amended to really specifically dial into a minor's consent to seek mental health services regarding their gender identity. Again, this bill failed, but as we're coming off the tail end of the gender affirming care ban that Nick Height and Lambda Legal are working on litigating, this was something that we're seeing as a continued effort. So obviously, we're very mindful of this continued attack, and we'll be working continuously in the preceding legislative sessions as these issues continue to arise. So just to be clear that this bill did fail this legislative session. And then a lot of the legislative wins were in the library field. And I really want to uplift the Louisiana Citizens Against Censorship and the librarians that put forward such amazing arguments and have really been working hard to defeat these continued attacks on our library system. So just a really quick overview of what was presented and failed. House Bill 414 by Representative Josh Carlson out of Lafayette sought to criminalize librarians and public library workers for providing access to books and information by removing libraries from exemptions in terms of Louisiana's obscenity laws. So criminalizing librarians and library staff under Louisiana obscenity laws. Again, to clarify, this bill failed. And it goes hand in hand with another bill, which was House Bill 545, authored by Representative Amity of Gray, Louisiana. And that sought to criminalize school librarians and educators for providing access to book and information and redefining what the concept of schools were in K through 12 and applying the Louisiana obscenity laws to those school librarians and educators as well. So again, this bill failed, but is a constant attempt to criminalize our librarians within our schools and within our library systems. Another bill that failed and was a repeat from a bill previously filed last year in the 2023 legislative session. And that was filed by Representative Jay Galley, and it was known as House Bill 640 and House Bill 946. And this was trying to seek provisions to the current law that establishes the library boards of control and would give governing authorities the ability to remove without cause at any time any library control member. So this is a continued attack to try and make sure that these library boards of control are filled with people that would align with banning or restricting access to books, especially LGBTQ books. And so again, in a second attempt, it failed again this year in the 2024 legislative session. And then lastly, there was House Bill 777 that was authored by Representative Dickerson out of Denham Springs. And this sought to make it a crime for any public official or employee to appropriate, allocate, reimburse, or otherwise expend any public funds to or with American Library Association, and to do so would carry a fine up to $1,000. So trying to restrict access to our library employees to the American Library Association. And to clarify, that bill also did fail. So one of the things that we know is that these bills continue to rise, continue to be authored year after year. And so we're going to continue to stand in solidarity with our librarians and our public school teachers to fortify the continued access for our youth and for the entire public to have the resources that they need, especially in a time of so much disinformation. It's very essential. So those are some of the bills that failed that were non-LGBTQ specific. Unfortunately, I'm going to shift over to 3 non-LGBTQ specific bills that did pass that are very concerning, not just to the LGBT community, but to the community at large and to the state of Louisiana. And many of you might be familiar with these. But the first and foremost, we had Senate Bill 123, authored by Senator Abraham, and House Bill 334, companion bill authored by Representative Amity, that was by the governor, and it provides for the employment or acceptance of volunteer chaplains in public schools. So obviously, as we continue to see a conflict between the integration of in the state, in our public education systems, this is obviously a warning and also goes hand in hand with the concern that arises over House Bill 71 that was authored by Representative Horton and was signed by the governor, and that requires the display of the 10 commandments in each classroom in public schools as of January 1st, 2025. I will say that opponents to this law, including us, but those including in the American Civil Liberties Union, or the ACLU of Louisiana, and the Americans United for the Separation of Church and State, have filed litigation against this mandate and cited the longstanding Supreme Court precedent that bars public schools from posting religious texts, just like the 10 Commandments. And so we're very thankful to the ACLU and to the Americans United for the Separation of Church and State for tackling this really difficult situation that we're finding ourselves in. And so I think when we look at the trajectory of what this upcoming school year looks like, we know that it's very, very challenging. And we want you to know that Forum for Equality, Louisiana Trans Advocates, and so many others are truly fighting for you, and for you to have access to the spaces and the places that we should all have access to, whether it's a restroom, a classroom, or a doctor's office. And so with that, I am going to pass it on to Nikhil, who is with the Family Equality Council. And they're going to be talking to us about some Title IX updates. And I know that there's a lot of information surrounding that. So I want to welcome them to kind of go over some of those difficult processes that are ahead of us. Thank you so much for being with us this evening.
Oh, of course. And thank you, Sarah Jane, not only for giving us some good news, but for that message to the LGBTQ plus youth. That was me not too long ago, I feel like, and I never heard that. And I think in Nathalie's words, I think I felt my heart chakra open up just a little bit, thinking about my child self hearing that. So thank you for starting with that message. All right. Well, hello, everyone. I'm Nikhil Vashi. I'm a non-binary attorney based out of Washington, D.C., and I'm Director of Education, Law, and Policy at Family Equality. I'm going to hold up my stupid vanity plate that says lawyer up. Same caveats as the other lawyers put out here. I'm not giving legal advice. Find a Louisiana-based attorney if you need that, blah, blah, blah. Caveats aside, I'm here to talk to you about Title IX and the ways that we can use it to create even more wins like the ones that Sarah Jane was talking about. So Nicholas and Alana already did a wonderful job explaining the new discriminatory legislation in the state of Louisiana. So I won't go over those again in too much detail. I want to dig more into how these laws might interact with Title IX. And then I want to talk about immediate steps that you can take under Title IX to protect your family from discrimination, and also where to look to for help with that. So first, just to ground us, what is Title IX? Title IX is a civil rights law passed in 1972 that prohibits sex-based discrimination in any school that receives federal funds, which is almost all schools. The Biden administration has interpreted Title IX to apply to sexual orientation and gender identity, and had already been enforcing that interpretation even before they finalized new Title IX rules in April of 2024 to clarify and expand protections for people discriminated against based on sexual orientation, gender identity, and something they call sex characteristics, which encompasses intersex people. So I think as already stated, the Louisiana state bills, HB 121, 122, and 608, openly defy the new federal Title IX rules, which protect LGBTQ plus students from bullying, harassment, and discrimination based on sex. For one, the new Title IX rules categorize misgendering and dead naming as a form of sex-based harassment, making HB 121's ban on, how did Nick quite put it, ban on affirming pronouns and affirming names would essentially make that ban unlawful. They also require that students be allowed to use school facilities like bathrooms and locker rooms that are consistent with their gender identity. HB 608's segregation based on biological sex also conflicts with this requirement. And both Title IX and another law, the Equal Access Act, prevents schools from banning extracurricular activities like gay-straight alliances as long as student-led clubs are allowed on campus. This, of course, can conflict with HB 122, which aims to restrict the formation of LGBTQ plus student groups and to restrict after-school discussions about gender identity and sexual orientation. Now, the new Title IX rule would have taken effect starting August 1st, making many of these provisions on their face not compliant with federal law. But unfortunately, the state of Louisiana joined other states in a series of federal lawsuits against the new rule. And federal judges have blocked the implementation of this rule while the Biden administration appeals their decision. As of today, the rule is blocked from going into effect in 15 states, including Louisiana. While I and many other lawyers view these lawsuits as without merit, we are living in an upside down legal landscape where anything can happen. So there's really no telling where these lawsuits might go. The only thing that we know for sure is that this is going to be a very, very long fight till we have a firm answer on that question. In the meantime, it is more important than ever to file Title IX complaints both with the school and the federal government. I think the way Nick put it is that schools are now in between a rock and a hard place between complying with the Louisiana laws and the federal laws that protect students. Personally, I think that that's an unfortunate situation, but just as the state is being the rock in this situation, we unfortunately need to be the hard place on these schools, because if there's only a rock and no hard place, they're going to listen to that side and not provide the protections that they need to be providing. While you might think that you cannot file a complaint because the judge blocked the Biden rule, that is far from the case. Your school and the Department of Education are still under an obligation to investigate any complaint you make, and your school has an obligation to make accommodations while the investigation is ongoing. Title IX is an important safeguard, but it can't be enforced unless you file a complaint if and when you experience discrimination. So some things to watch out for. There might be Title IX violations even while the rule is blocked. Repeated dead naming of a student. Refusing to allow a student to wear clothes consistent with their gender identity. Failing to address instances of bullying or harassment of a student based on gender identity or sexual orientation. Disciplining a gay teacher for talking about their spouse, but allowing a straight teacher to do the same. Even retaliating against someone for filing a complaint is in and of itself a violation of Title IX. There are many more examples I could go into. Sometimes book bans and censorship can even be a violation of Title IX. In Forsyth County, Georgia, the Department of Education found that a school violated Title IX for removing books with LGBTQ plus characters and authors from the school library. This was a huge victory that energized advocates all across the country, and it's a victory that never would have happened if people did not file that complaint. Even if you're not sure that you're ready to file a complaint or you want to file a complaint, one thing you can always do is ask to talk to your school's Title IX coordinator. Honestly, even sometimes asking to talk to the coordinator will send school administrators scrambling to do something. But I also do want to encourage you to file a complaint if you feel like you can do so. In a time where it feels hopeless or like we have no options, Title IX provides a tool that we can use to fight back against these vicious laws. In a way, it's a way for us to take the power back into our hands and put the other side on the defensive, forcing the school to explain why their actions were correct. So, even though this is a process that your school is supposed to give you all the information on and clarify, the fact of the matter is you're not always going to be able to get that help from your school. So if you want to know more about the process of filing a complaint or need to get some legal help, the first place I highly encourage you to look at is the Know Your Rights resource available on Louisiana Trans Advocates' website. In that resource, you will also find a link to Family Equality's step-by-step guide to filing a federal complaint. In addition, there are links to great nonprofits like the National Center for Lesbian Rights and the National Women's Law Center that actually help advise people on the process of filing Title IX complaints. And they have hotlines and email addresses that you can reach out to. And finally, I am also going to put out my email address in the chat. It's also available if you access Family Equality's Title IX guide. And I highly encourage any of you, if you have any questions about this or other school-based legal issues, to please reach out to me. I would genuinely love to hear from you all. And I really appreciate you taking the time to come out today to listen to us all. If there's anything that I can do to make your lives even just a little bit easier, please don't hesitate to reach out. Great. So I think that now I'm going to turn it back over to Peyton for our question and answer.
Absolutely. Thank you so much, Nikhil. I really, really appreciate you coming into Louisiana virtually and, sharing your expertise with us. Title IX is one of the strongest ways to fight these bills. So I really appreciate you sharing that with folks.
Absolutely. And I really do, please do take me up on that offer for help. I'm always here if you need me.
Absolutely. Thank you so much. There we go, guys. So now we're going to be moving into our Q&A. There have been a Q, and I'm going to bring on Sarah Jane Guidry from Forum for Equality to share the stage with me during this journey. Thanks so much, Sarah Jane. We didn't have a ton of questions being asked in the comments, but now's a great time. If anyone has any lingering questions, to throw it in the comments and we'll do our best to get it to you. Starting with the question we got before tonight's town hall. The question says, and this might have been covered, but I'm still going to answer it. So it says, considering that HB 608, which is the bathroom bill, says it applies to specific institutions / spaces, what is the potential impact on spaces not listed, such as parks, businesses, stuff like that? As Alana covered and whatnot, I think it's really important to note that it kind of depends on how the bill is implemented. Via its language, it could totally affect parks. It could affect the state capitol. It could affect public colleges. It could affect many different things, but we're going to have to see how it's implemented. Ultimately, what I really want to say to folks and remind folks is that the law is not a criminal law, it's a civil law, which means that if you find yourself in the situation where someone is challenging your gender in a bathroom and you have to deal with it, it's important to know that this is not a criminal law. You cannot be taken to jail for this law. And the only course of action in the law is that the person could sue you for it, which would take some time and is not an immediate thing. And if it happens, call us. But yeah, do you have any other thoughts to add to that, Sarah Jane?
I think one of the things that Alana touched on, and is a difficult concept that this bill and this now law, is addressing, is like the differences between private and public. So I think, when you use the term business, obviously private businesses, restaurants, places of work that are not public agencies or offices are not included in this. And so, I think taking the tips that Peyton and Alana addressed earlier in terms of safety should really be paramount in terms of the public spaces. And I think part of the question is also when I was looking at it, um, how are we going to know what's allowed in a given space, and how are we going to be able to assess that? And, again, that's the big question, right? Like, we don't know exactly how this bill is going to be implemented. It was not outlined. We have not received, and unfortunately, any guidance on how this will be implemented in different spaces. And so, knowing that, you should absolutely be putting your safety first. And as in a situation like this, making sure that you're using your best sense of the situation, that it's the worst sense of the situation going forward. Unfortunately, that's not necessarily something that I want to say, but something that I want to make sure that our community puts their personal safety forward in all those circumstances.
Absolutely. One of the questions that popped up in chat that I think is relevant is the bathroom law. How are they going to, quote, prove someone's in the wrong bathroom? Do you want to give some insight onto that?
I think, again, I feel like we are, and I don't want to be a broken record, but the bill itself doesn't really necessarily give clarity in terms of what that looks like. And a lot of the situations that were brought forward were discussing this exactly, is that there is no necessarily any proof in the situation. And, obviously one of the other concerns is that this can be utilized against any person. So understanding that this is obviously a very anti-trans bill, but it can be used against any person going into any restroom because there is no necessarily understanding of what that proof may be. So that's also why we consistently want to remind people that the safety is paramount. And so that in of itself is that there is no way that they can actually prove it. And I think that that's why Peyton was also trying to highlight that this is not a criminal act that would be put against you. So if somebody is attempting to bring a security officer or a police officer into this situation, utilizing that for your personal safety and saying that there is no violation in this is something that you need to understand in terms of knowing your rights in these situations.
Absolutely. There are a bunch of comments coming in now. I'll grab one. Also about 608. It says 608 has some exceptions for ADA, since gender dysphoria in some jurisdictions is considered to have ADA protections. Have we explored allowing shelters or other affected orgs to allow folks to use restrooms based on their gender identity? Is that interpretation? I would say that yes, it is something that folks should think about. Like you mentioned, ADA protections are kind of different. Like you mentioned, in certain jurisdictions, gender dysphoria is covered. So we're really trying to find out more information about how that plays a role here in Louisiana. But I think, I'm sorry, I'm not going to call this person out by name because I don't want to be, that seems inappropriate, but friend, I think you're on the right track with that thought process. And if you have like further thoughts or discussion that you want to have about it, you should totally reach out to us. At the end of the call, we'll be sharing some contact emails for the speakers. So yeah, Sarah Jane, have you grabbed a question that you could cover by chance?
Yeah, so I'm looking at the questions. I'm just gonna say that in terms of the Title IX question is, can another parent or resident of a school district file a Title IX on behalf of a student for whom they are a safe adult? I am going to re-reference the LTA's Know Your Rights section, specifically on the Title IX procedures. I personally don't know the answer to that one in terms of who, but I would assume that it would be the parent or the legal guardian of the student is being in question of the Title IX violation. But I would definitely reference the Title IX document in terms of that specific question. I don't know if Nikhil is still with us, that they could answer that specifically as a yes or no.
They say the answer is yes. If you're filing on behalf of someone else, you need to get written consent for that individual, which includes parents consenting on behalf of their child. Grab another question about 608. Says, if the school becomes aware that a SEL student is using the gender-affirming bathroom, are they now legally required to force that child to use the bathroom that aligns with a birth certificate? Yeah, basically. I mean, yes. The short answer is yes, and also because implementation and what's the word for when you enforcement, that's the word I'm looking for. Implementation and enforcement are not covered in this bill, so it's quite a sketchy area. I mean, no one carries their birth certificates around. It's sketchy slope. I think the school will want to follow the law, though, so they will very likely misgender the child via the bathroom situation. Is that your read on the situation, Sarah Jane?
Yeah, and I'd also, one of the things that HB 608, and I think it's Act 436 in terms of what the law's references, in terms of public schools, they have outlined the third option, which is a single-use occupancy restroom. So one of the things that I would say is that there's going to obviously be a lot of differences in the way that schools independently, and then also just school boards and parishes that are going to be handling this law. So I definitely would say that I would encourage, if you're a teacher or if you're part of the administration, I would engage in conversations on the policies in which that you can best provide for your trans students. And there are unfortunately outlines in the law that provide for those third options so that they aren't forced to use a bathroom that doesn't align. And I would also say that a lot of this information that's in this act does discuss birth certificates. So schools would have access, unfortunately, to that information. So if the administration or the school is aware of it, they do have access to that. Obviously, if this is a student-on-student situation, that would be different. But I think that as we're navigating this, I think that that is probably one of the best options in terms of discussions with parents and students on providing a space that's affirming, that isn't forcing them to use anything that would put them in harm's way.
Absolutely. I'm trying to stick with the 608 questions. The prisons are covered by PREA, like Elena mentioned. The prison, I don't know, it's a sexual assault protection for prisoners. And so PREA already has lots of regulations about how prisoners should be housed. And I think, I don't know PREA super deeply, so, maybe this is not a super correct answer, but to my understanding, what I do know of PREA, it is gender affirming. Sorry, I thought my internet cut out. So since PREA is affirming to trans people, I think prisons that follow PREA, apparently not all of them do, they should still be able to affirm affirm people's identities when they're experiencing incarceration. And I'll circle back to add about 608 that it has a part that says that that spaces should ensure privacy of people. And so that is why that's kind of it kind of forces people to follow it to ensure privacy. Let's switch to, I'm going to scroll up. We got a question about the chaplain bill. I warn everyone that outside of the direct queer bills, we're not experts on anything, but it gets sketchier after that. The chaplain bill, it says, can we get more info about the chaplain bill, as in who's defined as a chaplain, educational requirements, etc. It's my remembrance that chaplains are not defined and that there are no educational requirements for them. Do you remember anything differently, Sarah Jane?
No. So again, a lot of these bills are written in a way that they're able to be adapted independently by school boards and schools. And, one of the conversations that we've schools are required to learn is that that these school chaplains are they're either hired or they're volunteers. So there's two different classifications. So you can have a chaplain that volunteers at the school, and then there's no school budget for it. But we want to I think one of the biggest concerns that we have in terms of this bill is making sure that school counselors aren't being replaced or underutilized and being replaced by chaplains in these situations. And so obviously, as we see the school year unfold, we'll be watching the situation very closely. And that's, it's unfortunately a wait and see situation.
Yes. Moving along to a question that says, does Title IX apply to school, teachers, staff, etc., or does it only apply to students? The answer, thank you, Nikhil, is that it is thought that if the school knows of bullying or harassment coming from another and the school fails to stop it, that stop it and cure the harm. Wow. And then, yes, that could be the basis of a Title IX complaint. So, yes, I guess it applies to everyone in that way. I feel like we've answered most of these questions, Sarah Jane.
I know, bear with us.
One question I did see earlier was about the 10 Commandments bill, if there was any update. To my remembrance, there's no updates about the 10 Commandments bill. I believe they've asked for a temporary injunction in it, which would, I don't know. Don't quote me. There's no update. That's what I know.
Yeah, so as of now, there's no stay that's been issued in the case challenging the law and displaying the 10 Commandments, but they have filed a motion for a preliminary injunction, to my understanding, to block the implementation, but and to stop it and preventing it from taking place in the new school year. But at the time, it's still pending. So yeah, so that is the update, is that it's been filed, but there's just action on it by this point.
Yeah, courts are not known for their swift decision-making abilities. I really think that's all of the questions. If anyone has any questions that we missed, please resend them or re-uplift them. We'd love to be able to help out. Oh, that's a great question.
I don't know the answer to the actual specifications that are going to define a chaplain. And how one of the questions was, so as an ordained dude, a person could be a chaplain to schools. Obviously, I think the process would be a little bit more involved in terms of the school hiring said ordained dude. But I mean, I would much rather have an ordained dude than in my school. But that being said, there are definitions. We don't know them off the top of our head in terms of what is included. And then obviously the school would have to accept the volunteer position or paid position of said chaplain. And so I think it's definitely going to be like all of these situations, and as these laws have been created, a case by case situation. And I think that has been a strategic process for these laws altogether in terms of them being very vague, very overwhelming, very cumbersome, very harmful, and inflicting a lot of continuous chaotic harm. So, one of the things that we can look at as a whole in terms of all of these bills is that we have a law that puts chaplains in schools, that puts 10 commandments on a law that does not allow you to discuss queer people and in classrooms. It allows for you to not use a person's name or that are gender affirming, and this is coordinated and it's going to continue, and we want you all to know that we're following it and working on it as best we can. Louisiana really has become a front line of a lot of the issues that we're going to be seeing nationally, and we're also absorbing a lot of laws and bills that other states have been dealing with for the past 5 years, and really this post-pandemic attack on the queer community, because we have this new governor and administration that is welcoming these very harmful, very discriminatory laws that obviously spread farther than the queer community, but we are feeling the reverberations of that. And so while all of this is so much information, I do want everyone to know that it is being recorded and it is here as a living document again, that you can come back and reference it. And Peyton and myself are always available via email. And if there are questions that we did not answer fully, or if there's more clarification, either one of us or one of the wonderful people that was with us this evening will be able to answer them. We realize that we're going to be having a lot of questions because, again, these are case by case situations. So I really do appreciate everybody that was here this evening, taking up time to really delve into difficult topics. I highly encourage you all to share this as a resource within any organization that you think would be helpful, whether that's your parent teacher organization, whether it's your PFLAG chapter, whether it's with your neighbor or parents group that you are in, anywhere that you think that this information could be a resource, please share it, because we really are here for you during these really difficult times. And also just remember just the joy, beauty, and resilience of our community, and that we're all going to be standing arm in arm. And we have wonderful national partners that are here with us. And I really want to uplift Peyton and all the just work that she and Louisiana Trans Advocates have done, and as well as a lot of organizations that are not necessarily here with us, but have been putting in the hard work and effort this legislative session and before us. And so we stand on the shoulders of giants. We'll all continue to walk together. So again, thank you for being here this evening, and I'm going to turn it over to Peyton to kind of.
Love it. Thank you, Sarah Jane. My mouse is not working. Kind of love that. Okay. Thank you, everybody. Wow, what an evening. It's now fun to talk about all the terrible stuff that is happening, but what helps me survive through it is being around all these amazing people that lift you up when you're down and give you a hug when you need it, and will bring over food at the end of a hard day. So I'm just really grateful to be in space with everyone. And thank you all for coming. I mean, most of you stayed here the entire time. I think that really shows dedication throughout, through y'all, and I just so appreciate that y'all care so much about yourselves, your kids, your family, your friends, whatever brought you here today. It just means a lot. To give us some closing items, I'm going to be dropping some links into the chat or the comments. I'm going to be dropping LTA's Know Your Rights directory into the chat. I'm going to be dropping Louisiana LTA's transaction team into the chat in case people want to, stay involved and stay informed. And I'm also going to be dropping the emails for the speakers that offered that throughout this presentation. So you'll be seeing that shortly pop up. And in the meantime, I'm going to pass on over to Natalie. Thank you so much, Natalie, for grounding us in this space and bringing us here. And I am just so grateful to have you here. Our work is hard, and it's really important to be intentional about taking care of ourselves and moving through all of the kind of gross energy that we deal with. So thank you so much for being here with us and contributing your love and energy.
Thank you. I'm like, oof. We stand on the shoulders of giants. I'm like, I stand next to giants every time I come to this space, the local space. Peyton, SJ, I stand next to giants. And so thank you for just being such a leader and someone that I can look to feel a little bit better, a little bit more fortified in this moment. And thank y'all for having me. I'm with the Southern Organizer Academy, and we're all part of LOCAL, the Legislative Organizing Coalition for all LGBTQ Louisianians. Excuse my camera angle. I had to switch spots because of connectivity. But y'all, just as we started with intentional practice of humming and taking care of our bodies, I wanted to kind of end us tonight with some future visioning. And so not only is healing justice about making sure that we are whole and that our kindreds are whole, but the people who have been doing this work and who are going to come after us for the next 7 generations, that they can also be in a practice of wholeness as well. And I'm not saying that I'm perfect at it. I'm not saying that I have all the answers, but I think collectively, we all have some medicine that feels really strong and powerful. And so what I'm going to do is I'm going to ask us to lean back into our number 3. The number 333 is the angel number for alignment, meaning that we are doing in the right way. We are moving in alignment with our ancestral and individual wisdom. And after those 3 breaths, I'm going to ask folks to close their eyes, look at the wall, find a place where you can soften your gaze. And we're going to do some future visioning. And for folks who might not get the connection, future visioning is one of the first steps to building out collective strategy campaigns that win. When we're able to vision things and see what we want in the world, we're able to then make the steps and the strategies that can complete those visions. So I'm going to plant some seeds today that might not sprout until next legislative season. That might sprout tomorrow. That might have already started sprouting and growing, right? But the intention is to be in a practice of radical imagination so that we know that nothing is impossible. We've already learned, right? Tonight, all these bills that have been passed, we already are actively organizing against them in ways that are beautiful and powerful. And so I'm going to ask folks to breathe in so deeply that your belly extends. And when you exhale so deeply that your shoulders drop. Maybe give it a little wiggle. And then breathe in again so deeply that your stomach extends. And exhale so deeply that your shoulders drop. And for the 3rd time, I'm going to ask you to breathe in again, so much so that your belly extends. And exhale so deeply that your shoulders drop. Return to any tapping that you might need to do in your body. You can keep your eyes closed. You can soften your gaze. You can look at the wall, something that comforts you. And then when you can, I want you to focus on these next few offerings or prompts. Imagine ourselves in the future. It's 2025, it's 2028, it's tomorrow. And I want you to imagine young folks dancing, playing, in all genders of all sizes, in all their glory. I want you to imagine them having full access to all social spaces, including bathrooms, including playgrounds, sports teams. Imagine the victory when they're at the state capitol. Imagine them planting seeds. Imagine them on the playground. Imagine educators and teachers with true access to freedom of speech, being able to talk about who they are, being able to talk about how they live, or deciding that they don't. I want you to imagine when we're in conversations with each other, when we're in conversations with other legislators, the clarity in our language and our strategy. Something tonight we learned is that the language in these bills are intentionally a hot mess. I want us to imagine having strategy in language and laws that are so affirming and so clear that no one can second guess our inherent value, our inherent worth. And as you continue to breathe, be reminded of the tools that we have at our disposal, that we are the hard place and we stand in that power. Be clear that there are organizing strategies, there is food, there are hugs, there's physical love, spiritual love surrounding us. Imagine a warm gumbo going through your body after we even passed a law that is sickening and no one can stop. Imagine the embrace of a fellow organizer or a fellow young person as they go off into play on their sports team. Imagine the buddy system in play as people use the restroom. Know that we have tools, strategies, each other to get through being the hard place and to move us into the places of clarity and affirmation of our names, our identities, our bodies. As we take one more breath, I want us to be clear and see and witness the fullness of this new world that we're building, that we're imagining. A world in which our organizers, our young folks, our families, we individually are fortified in every sense of the word. I want you to imagine, what does it feel like to be fortified? Does it taste like good food? Do you hear some good Zydeco music? You hearing something on the radio that's a celebration song? Do you smell the fortification in an herbal blend? Are you smelling the food? Do you sense of touch? Is it a hug? A high five because we did the damn thing? And what are you seeing? Take a moment to look around you in this future that we're building together. Do you see young folks, trans, queer, gender nonconforming in celebration? Do you see a coalition across the state that extends across the state to across the nation, to all around the world, of people who have your back? And finally, let's take a moment to breathe that in and submit that future vision. We're going to breathe in so deeply that our bellies extend. And we're going to exhale so deeply that our shoulders drop. As you come back into the present moment from this beautiful future that we've built, where we have everything that we need, allow yourself to touch yourself somewhere. Give yourself some love. Knowing that we've already planted the seeds to win, to support our young folks, to support each other. We've already saw it. And now we just have to continue to do the work that the people who came before us have done, that we've been doing since I've been part of this coalition, and that we will continue to do long after we're gone from this space. The answers are present And we just got to continue to walk forward together. Thank y'all so much for being with us tonight. So as we said before, this is going to be recorded and sent out as a living document. Please return to this anytime you need to. Reach out to any of the speakers. Reach out to me if you want to be in conversation around wellness and how you can incorporate it into your work. Know that we're doing this together, that nothing is impossible. And in fact, whenever we've stood up for ourselves, we've organized, we've mobilized, we've often won. I hope y'all have a great night. Take care of yourselves. Do something special for yourself tonight. And remember that we'll be here. Good night, y'all.